topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talkboard TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good afternoon, South Florida. Welcome to another Ask the Expert show, where for the last 16 years, we bring you the finest experts in the field of legal, health, financial, and home improvement. This is the first Thursday of the month, 5 o'clock Eastern time. That means K. Bender Rimbaum. Hey, before we get started, I just want to thank everybody, first of all, for wishing us a happy Passover. I really appreciate that. I know our expert guest on today also appreciates that. But, you know, when you people take the time to just write us how much you're enjoying the show or you send your questions, I can't tell you, it's so appreciative. We read every single one. I wish we could get every question on, but the show is 50 minutes and we could go 2 hours easily. But let me welcome you to attorney, my buddy, Robert K. Good afternoon, Robert.
Good afternoon, Steve. Hello, everybody.
So I want to wish you a happy Passover.
Same to you and everybody out there who celebrates.
Yeah, I should send you my Hiroses. It's the best in the world. I'm just playing with you.
Don't just talk about it.
yeah, that's right. Hey, Robert, I got to tell you, I wish I could say our longest. You are our second longest running show. And I got to tell you, people love your show. I know that you give up an hour of your time each month, but it is so well worth it. I can't tell you how many board members and management companies and residents just love your show, the advice you give, how you communicate it. And I just wanted you to know you were so appreciative.
Well, I'm happy to hear that. And certainly I have a good time doing it as well. So it isn't necessarily such a burden.
Well, what we do every month is we ask you to send your questions in. Please, if you can, remember to let us know if you're a condo or HOA. It makes a huge difference. By looking at the YouTube numbers, how they go up every month, that means we're getting new listeners and viewers. Robert, tell people about K. Bender Rimbaum.
Well, K. Bender Rimbaum is a law firm here in South Florida primarily. We started in Fort Lauderdale, now in Pompano Beach, providing specialized services to condominiums, HOAs, and cooperatives in the community association field. We do this out of offices, as I say, Pompano Beach, Palm Beach Gardens, Orlando, and Tampa. We have a meeting center in Miami for appointment only as well, but we're available across the state. With the technology out there today via Zoom, we have Zoom meetings going much of the day in all of the offices. So we provide legal advice and services to community associations for all aspects of their day-to-day legal needs, be it a review of the governing documents, advising the board of their rights and responsibilities, dealing with covenant violations among the owners and visitors, contract negotiation, loan negotiation has been a big thing in recent times. Dealing with government issues that might come up, zoning and code violations, dealing with construction defects, bringing claims under relevant statutes that may involve developer claims for new communities. Pretty much anything you can think of that a community association will deal with on a day-to-day basis legally. These are the things that we do.
So
my left collection of assessments. That's another good one.
Yes. So I want to get to the chat line, because when we did our Orlando show, people were upset, but we had so many questions. We couldn't get them all in. I'm going to start with the chat line today from Gina. Thanks for this broadcast. Her HOA management company is on the third owner in 5 years. Current owner dissolved the original company and it's under a new name. No new contract has been signed.
Well, is there a question here?
Yeah, is there a question here? Maybe they'll follow it up with the question. Let me go.
Well, these situations certainly occur not unusually, but you need to look at the various contracts to see the original contract to see whether or not there's any limitations on assignment or sale of the company. If the management company is not performing and the community wants to terminate it, then there's a ability to do so for material violation of the terms of the agreement, whatever agreement might be in place. Typically in Florida, unless there's a prohibition on assignment of any contracts of that nature, they're considered freely assignable. The board is certainly within its right to ask the management company for a new contract, and if they aren't willing to provide one, they could consider them to be no longer under any contract beyond a month to month. But whatever you do with that, I suggest that you do bring in association counsel to make sure that you're not going to find yourself facing legal challenge that could get expensive in that regard. So sometimes they get very protective of their contractual relationship and not all that willing to let you just walk away.
Well, she did follow it up with the question, do they need to sign a new contract?
Yes, I see.
Okay, let's go to, is it legal for a board member to not own property in the HOA? And can spouses serve on the same HOA board, or is that a conflict of interest?
Are we talking about condos or HOAs? We don't have that, right?
HOA.
HOA, okay. Under Florida law, unless the articles of incorporation require membership, which is what ownership is typically defined as in the association, then there is no requirement that there be membership to serve on the board. So you want to check your articles of incorporation to see if there is such a requirement. If it's not there, it doesn't say specifically that a board member must be a member of the association, then they do not. This is the case even if the bylaws do contain such a provision, because that would put the bylaws in conflict with the articles. And when there's a conflict between the articles and the bylaws, then the provisions of the articles will control. So you do want to check your articles to see if that's an issue. Husband and wife in an HOA setting, I know that in a condominium that's something the statute addresses. I'm trying to remember off the top of my head if HOA is the same way. I can confirm that, but I don't believe that HOA statute has such a limitation on husband and wife service on the board. It's not a conflict of interest. If they're both members, they're both qualified. In the condominium setting, that can only happen if there's nobody else that is willing to serve on the board. So that's an issue that they can look into.
Next question. This is regarding violations fines. Can one board member alone issue violations or fines? Shouldn't a fining committee be independent from the board? And are fines enforceable if due process was not allowed?
Well, the way the fining works under the statute is the board is the one that adopts and imposes a fine. However, the fine is not finalized until the fining committee has a hearing and decides yes or no as to the decision of the board. If the board has delegated the responsibility to identify violations and impose fines to an individual board member or officer, that's certainly something that the law allows, but there would need to be something in the records of the association that identifies that delegation of responsibility to that particular board member. That would need to be likely in the minutes of the association's records from board meetings when such a determination was made. And so in order to fine, there has to be a violation that has been identified, and the board has set up parameters for what fines would apply and how much, whether it's by the day, et cetera, up to the statutory limitations or whatever the documents provide for limits. And then the matter gets referred to the fining committee to hold a hearing with at least 14 days notice to the violating owner. And then at that hearing, the owner, it's like a mini internal trial where the owner can put their defenses up. It's not something that necessarily allows you to bring an attorney to represent you, but the owner is being the defendant, the board is the prosecutor per se, and the fining committee is the court to make the decision yes or no. It's only yes or no on the fine that's been requested. It's not up to the committee to negotiate the fine or try to come up with something else. It's just simply yes or no.
Next question is, can an HOA refuse or delay access to documents like the bylaws or governing docs or HOA financial records? And can homeowners request an independent audit?
The first part says, can they delay access? No
Can
reason.
Yeah, it says this is an HOA. Can they refuse or delay access to documents like bylaws, governing documents, or HOA financial records?
Well, the statute requires that documents be made available, or I should say the official records be made available for inspection and copying within 10 business days of receiving a written request. So you can delay it up to 10 business days, but you can't delay it longer than that without the possibility of being in violation and found to be in willful violation that results in a fine of $50 a day up to a maximum of $500 or such other damages if it does go to court that a judge would decide has occurred. So not sure why you'd want to be delaying access. But as things are evolving, many communities are having their documents put onto their website and are able to have owners access them that way. Homeowners can request an independent audit, but they can't force one. If the homeowners want to have an independent audit and pay for it themselves, that would be part of an official records inspection request. And they can make an appointment to do that. If the association has limitations on how often records inspection requests can take place, the audit has to fit within the parameters of those limitations.
And another question from our chat line. Can the HOA retaliate against me for challenging them? And how can I protect myself?
Well, the association is not supposed to be retaliatory in the way it operates, but sometimes human nature is what it is. And if there's a basis for the association to make a legal claim against this particular questioner, it's a possibility, but we don't counsel our boards to act in a retaliatory fashion. And with regard to protecting yourself, it's hard to say without more information as to what's going on and what kind of claims are being made. But it might be good to have an experienced attorney available to help counsel you in dealing with issues that if you have such a relationship with your association.
Here's Matt and Boynton. Our attorneys, our board members love watching your show every month. Thank you so much for bringing such great information. Is it the property manager's job to verify the 80% age rule, or is it the board responsibility?
Everything is a board responsibility when it comes to the operation of the association. And it may involve its management company to assist it in handling administrative issues and gathering information. But ultimately, the responsibility falls upon the board. In this situation, what you're talking about is housing for older persons that has requirements under federal law that at least 80% of the residential units or properties have at least one occupant over the age of 55 years, and that the association has to confirm that with a periodic census. That's generally done every 2 years. So management companies typically assist with the census process, but it's ultimately the board's responsibility to instruct that it be done and that it becomes part of the official records of the association to contain that verification. Now, the 80% is often misunderstood. Under Florida law, you're supposed to have 100% compliance, not 80%. And the 80% is what the federal law allows to maintain the exemption to legally discriminate and keep children from residing in the community. But you're supposed to strive for 100%. The 20% buffer that's there is supposed to be used for situations when, let's say, the spouse passes away and is over 55 and the surviving spouse is under 55, or children under 55 but older than 18 survive the individual. They would not be kicked out because of the fact that none of them are 55 unless they fall below that 80% number. So it's not supposed to be used to say, well, I like you, so I'm going to let you not have somebody 55, but everyone else has to have someone 55. You have to strive for 100% compliance on that point.
Reed in Boca Raton. I'm a board member of an HOA. This is the month of March, and I cannot get the January 2026 bank statement. Do I have the right to go to the bank and get it?
Well, that depends on the relationship the association has with the bank and who's been identified as an authorized individual on the account. It's unclear why you wouldn't be able to get the statement for January by March. That should be something the association has received. Now, if the association works paperless and only accesses it by going online to get it, whoever is authorized to go online should have done that already, and it should be part of the official records of the association.
People in our chat line, thank you so much. We're getting your letters. We will be getting them in on the show. I promise you this today. You've got such a busy schedule, the month of April, Robert. You want to go through
busy,
those?
But there's some good stuff in there.
There's some great stuff in there.
Sure. You want to hear about it?
Let's hear about it.
Okay. Starting with April 8th by Zoom, we have a presentation before, during, and after the storm, a board's operational playbook at 12 noon with Jeff Rembaum. He'll join a panel hosted by Nescor Management Partners dealing with hurricane preparedness. Then on April the 15th on Zoom, we have a legal update for the 2026 for managers and condo boards. The legal update for 2026 are changes in the laws adopted by the legislature in 2025. And just so everybody knows, no laws affecting community associations were adopted in the 2026 legislative session. So there isn't anything new to report on that. On that Zoom session, there is some CEs for 2 CEs for CAMs and 1 CE for condo boards. It'll be at 2 p.m. Be presented by Danielle Brennan from our Palm Beach Gardens office. On April the 16th, there's an expo in Broward County that runs from 8:30 in the morning till 4 o'clock p.m. at the Broward Convention Center in Fort Lauderdale. We'll have a booth there, and we will be presenting 2 classes. The first class at 10 a.m. will be guest restrictions and screening. That'll be that's going to be at 9 a.m. The booth is at 10 a.m. 9 a.m. to 10 a.m. There's going to be a CE for CAMs and HOA board on guest restrictions and screening. And the 2026 legal update will be presented from 2:30 to 4 p.m. with the same CE for CAMs and condo board annually. Then on April the 17th, we have the HOA board member certification course. So there you go, HOAs. Also a Zoom class at 10 a.m. Kirsten Hentz from our Tampa office will be presenting on that date. On April the 22nd, we have another Zoom presentation, the condo board member certification. So we've got both happening. This one's going to be a little longer, and it'll be at noon with Kirsten Hentz from Tampa and Alan Schwartzide from Orlando. So the people in other parts of the states will present. Oh, and I didn't want to skip on the 21st of April, the Palm Beach convention our expo will occur at the Palm Beach Convention Center in downtown West Palm Beach, 8:30 to 4 p.m. The same 2 classes will be given, guest restrictions and screening from 9 to 10, and the 2026 legal update from 2:30 to 4. So that's what we've got for April.
Well, I got to tell you, we do other community association shows in other states, and they don't have anywhere near the amount of classes you offer. So for you, it's not a big deal, but we're used to maybe 1 or 2 classes a month, maybe. It's just K. Bender Rimbaum offers so much. We're going to go to a break right now. We're going to come back. I'm going to get to your questions in the chat line. Robert, tell people how they can reach your office.
You can reach us at 1-800-974-0680 for any of our 4 offices, or you can write to us at info@kbrlegal.com, or you can go to our website, kbrlegal.com. There's a contact box on the home screen that you can fill out, and then someone will reach out to you. Also, with respect to these classes, you do need to pre-register. So you want to go to kbrlegal.com and click on the calendar of events and choose the item that you want to register for so that you can reserve your spot and get your sign-in information.
We're going to go to a short break. We'll be right back with more K. Bender Rimbaum.
K. Bender Rimbaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Rembaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Rembaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
We are back. This is the first Thursday of the month. It's always our K. Bender Rembaum South Florida show. We always do the show with one of the senior partners, attorney Robert Kay. And I'm going to get to your questions. This is sort of a long question. I don't know if, Juan, you want to highlight it. They didn't have enough room, so they had to write it in two boxes. But we have a board member who has been on the board for 13 years. He will be placed on the board again on the 15th of April at our elections. Can he serve past the 8 limit by the new statute? Can he serve out his term?
And then it goes on, right?
Yeah, we have other owners who want to serve on the board when his 8 consecutive years expires. Will he be able to serve out his full term, or is he off on July 1st?
Well, it's not a new law. The law was adopted in 2018 for condominiums only. The question doesn't say if this is a condo or HOA, so I'm going to assume it's a condominium. As of July 1, 2018, the limit of 8 consecutive years was imposed with certain situations that may allow for it to go longer than that, such as no one else willing to serve, or if a supermajority of 2/3 of the owners vote to keep that individual on the board. But again, bear in mind, this is continuous service, and if this individual gets elected again, that creates some potential problem. So if your election's on April the 15th and he gets elected again, the service will continue until the next annual election, presumably next April of 2027. It doesn't happen that when you cross the July 1 threshold of the 8-year limitation that you're automatically off. You retain your position until the next election that follows. So if your election wasn't until after July 1, then the limitation of the prior 8 years would be in effect. So the 8 years only begins to run July 1 of 2018. The prior 5 years that he's been on the board aren't really something you'll count for this particular statutory limitation. But if other people want to run, then what they need to do is get owners to vote for them. And hopefully there's more than just the same number of candidates as there are seats, because that's another situation that would allow the individual to serve beyond the 8 years that the statute limits.
You were right. It was a condo they just wrote in. Our next chat line is, I've received conflicting information about MRTA and when the 30-year period begins. Does it start from the declaration recording date or from each property's deed date when sold by the developer?
Well, this is actually a very complicated and technical legal issue as it's been drafted by the legislature through the years. MRTA is the Marketable Record Title Act, and it provides that certain documents that are recorded in the public records in the state of Florida will expire at a certain date after 30 years, unless the board does something to renew them and allow them to continue for another 30 years before the expiration. If they wait till after the expiration, then they're going to have to get a vote of the owners to allow the covenants to be reinstated. So you want to make sure you take that action before the 30 years is up. A lot of people use the recording of the declaration of covenants as the date to start counting from, which is really incorrect. It's actually early, because the statute refers to the first root title in the title chain process. So really, it's the first deed that's been granted by the developer for that property. So each property within the community could have a different date that the 30 years runs from, which can be very confusing and complex when trying to figure out when this document is going to expire. You don't want to deal with this particular statutory provision without involving experienced counsel who can assist the board through the process. And hopefully that experienced counsel fully understands how it works. Going with the date of the declaration is safe because it's earlier than the actual expiration date. If you're looking to do a republication that will just allow it to continue through the years without having a vote of the owners. If you have to do a resurrection of the document after the expiration, then the expiration date becomes more important, to be precise. And that would take a much more involved review of the public record to see when these deeds were first given. You also need to look at the language of the deeds to see if they've incorporated information to sufficiently identify the declaration that was recorded before it and tie it to the community. If that's in the original deeds and carries over and through the years, then the documents aren't going to expire under the Marketable Record Title Act. So this is a very complex provision in the law, and it's not one that people should try to get involved in without the assistance of knowledgeable experts.
Oh, here's a great one from Trace in Fort Lauderdale. Our residents listen to many podcasts. Yours is the only one we listen to the entire show. Your show is the most talked about show at our condos. My question is, our condo was built in 1970. It's 8 stories. Can a board decide on their own to permanently close the trash chute? I'm 70 and we have several handicap owners.
Well, I would like to give you a specific affirmative answer to that, but I don't think I can without more information. In order for the trash chute to be considered part of the common elements that cannot be simply shut down by a vote of the board, you'd have to review the governing documents to see how they are identified, if they're identified. The board is not in a position to materially alter the common elements. And if this is part of the common elements and shut it down and take away amenities of the association or of the residents without getting a vote of the owners in many situations. If the trash chutes have fallen under disrepair and are no longer functional in the way that they need to be functional, that's something the board should be undertaking necessary repairs to. But the owners are going to have to bear the expense of that. So you want to be careful what you wish for, because if you find out that the board has to fix it and it's going to cost, an assessment of $5,000 per unit to get it done, is that something you necessarily want the association to be spending money on? You want to have the owners at least involved in that type of decision and not have that imposed upon them. So More information would be helpful. Certainly, you want to bring in experienced counsel if the board is just doing it on its own and shrugging its shoulders to the owners.
Vance and Delray, I think this is a management company. He says, I have an owner who mounted a camera aiming up at a landing above the courtyard towards building towards neighbor he doesn't like. Claims it is to protect his front courtyard from theft from people swinging over the railing. Please advise, he is the only lower unit owner that has done this and has an open conflict with this neighbor.
Well, it's another issue that depends on what the documents provide for limitations on putting cameras in and around the property, and whether or not that's something the association has adopted a rule about or otherwise has restrictions in the governing documents. If there isn't any, then the matter becomes one between the two owners. And if the one owner who feels like their privacy is being encroached upon by the placement of the camera feels the need to address it, then that owner should be addressing it directly with the neighbor who installed the camera, not involving the association. Generally, the association wouldn't get involved in things unless there's something of more common interest to more than a single owner within the community. Otherwise, it's a neighbor-to-neighbor dispute.
Molly and Boynton, we are an HOA. We get questions like this all the time. We only have 2 board members and we can't get a 3rd board member. How do we get anything done to our property? We have tried so hard to get a 3rd board member. We can't get trees trimmed or pressure washed.
This sounds familiar to me. I think we talked about this on a prior show that we did, but if your total board is 3, then 2 is a quorum of that number, and you don't need 100% attendance. If the 2 of you are there and participating, that's a quorum, and you can properly function as a board. If, however, the total number of seats are 5 and you need 3 to have a quorum, then you have a problem and you can't function unless you get at least 1 or 2 more board members so that you can have 3 participating. If you are unable to get anyone else to participate on the board, if your documents require the 5 members to be on the board, you may need to somehow figure out a way to amend the documents so that you can reduce that to 3 so that you can function. The only other option available is to petition the circuit court, which any owner can do, for a receiver to be appointed to operate the association until such time as an election can take place to establish a full board to operate the community. The downside with having a receiver is that the receiver stands in the shoes of the board, and they get paid for their services at an hourly rate that can add up quite quickly, and the association has to pay for their services. They're also allowed to hire an attorney and other professional individuals that the association would also have to pay for. So it can get very expensive having a receiver operating your community and when the owners won't have anything to say about it. The primary function of the receiver would be to operate until a board can be elected, and they should be holding an election to get that to occur.
You know, I've learned this from you, Robert. You know, we get a lot of people complaining about their board, things not getting done. But I got to tell you, if you're so worried about that, run for the board, which is going to help you get these changes made. You can't sit in the dugout and do nothing. I think I learned that from you, Robert.
Oh, that's certainly a good way to resolve some people's problems, but other times it's a political situation that becomes difficult to overcome. Sometimes the loudest voice is not necessarily the most reasonable voice, and then they're not going to necessarily be able to secure the support of enough people to get elected. And that can be very frustrating for that individual as well. And then they continue to come after the association for everything that they can think of. So it isn't as black and white as we like it to be, but certainly be involved, come to board meetings, participate, serve on committees if you can, and then get involved in the political process.
Rebecca in Miami, this is a condo. She said her docs say all people who live in the condo must be 55 or older. Can a daughter under 55 live in the unit?
I would want confirmation that the documents actually say that all occupants have to be 55 and older, because that's not the law. The law is that there be at least one, and that the age of the owners is not a relevant concern. It's who are the residents. Quite often it comes up, there's an application that's going to be purchased by someone who's under 55, but they've indicated their relative or somebody 55 or older is going to live there. Is that going to be allowed? And the answer is typically yes, because it's not a restriction on who can own it. It's a restriction on who must occupy it. So I would want confirmation that the documents actually say that, because if they do, that's probably in violation of fair housing laws, particularly like the state of Florida has a limitation on restricting based on age, other than to comply with the Fair Housing Amendments Act of 1988 as amended, to allow for housing for older persons. You're not allowed to use age as a basis to determine somebody's occupancy. So if their documents actually do say that, they should bring that to the attention of their legal counsel and see if they need to do something about that.
Going to our chat line, is there a legal way to verify that an animal is actually a service animal and the letter submitted is legitimate? We suspect that there are owners who have been submitted false documentations.
When you're dealing with somebody who's seeking reasonable accommodation in a no pet community, you should involve the association counsel to assist the board in evaluating the information that's provided. Through the years, this is a situation where the association can be guilty till proven innocent when they try to do their due diligence to confirm whether somebody actually complies with the law and qualifies to have an emotional support animal or a service animal reside within the unit. There has to be something in writing from a medical professional. It doesn't have to be a doctor, but a legitimate medical professional who identifies a major life function of the individual that is impaired, and they don't have full use of their property without these assistance of either the emotional support animal or service animal that's there. You can certainly look at the credentials of the individual who's providing the documentation. You can look into whether or not this is somebody that's actually met the person, or it's one of these online churning places that from California or some other state that just sends out letters without really knowing the people. Florida statutes does make it a crime to pretend to qualify. So, the pendulum has been swinging in the other direction in favor of associations to allow them to make more certain. But do involve your attorney to make sure on any issues so that you minimize your potential of a discrimination claim being made against the association. Those can be relatively expensive if you find yourself stuck in that.
Leslie in Pompano, your backyard. May an owner in an HOA start a non-related website, Facebook or otherwise, for owners to come get selective enforcement pictures, emails, documents, again, non-related to the HOA?
There is no restriction under the law for individuals to do that, so long as they don't violate any copyright issues or present in a manner that the reasonable person might be confused into thinking that some official association site. There should be some disclaimer on their site that they're not a part of the association and that the opinions that are expressed within this particular site are those of the writer and are not of the association, the board, or in any way binding upon the association. If they do that, they should be fine in setting up such a page for owners to participate in.
You know, we got a few minutes left. I've got to ask a special question because we get a lot of people who write us that say after listening to your show, this is in Orlando and Tampa, that after listening to your shows, they're having second thoughts about the law firm that represent them. So tell people what makes your firm different.
Well, we have extensive experience in the field. We have at least 10 of our attorneys, I believe, at last count, who are board certified specialists in community association law by the Florida Bar. I think there might be 200 in the whole state. This requires a level of experience and understanding and also the ability to pass a fairly comprehensive exam that the state imposes, as well as a higher level of ongoing continuing legal education requirements to maintain the status as, and then we're able to call ourselves experts under the law and specialists. Attorneys are otherwise limited from using that terminology so as to not confuse the public. We've been providing legal services to community associations continuously since 1992 and have grown to the point where we now have the 4 offices. And with the technology that's available today, we pretty much can cover the whole state of Florida without any kind of an issue. We have organized ourselves to provide our services in a way that's more user-friendly to our board member clients or our association clients, who are quite often run by lay people, not professionals in the field. And we make our opinions so that they're understandable to the general population, so you don't need someone to translate for you what we provide to you. We believe that we're in a service industry and that you're not calling your attorney because you want to wait a week or a month or however long it takes to get the information you're looking for. We try to provide this in a timely fashion and in a cost-effective fashion. Certainly, attorneys are not inexpensive, but we try to make it as cost-effective to our clients as we possibly can in light of what we deal with in the world today. When you call our office, you get a live person. When you reach out to us, we respond that day or within a day that we've got your inquiry and that we're working on it, or we give you a substantive response. That's something we instill in all of our attorneys, that clients need what they need and they need it as fast as we can possibly give it to them. So those are some of the reasons why I think a lot of the clients we've had. I'm proud to say that we list our clients in numerical order, and we still have client 0001 continuously since 1992.
And I've learned from you, customer service is so important to you.
Absolutely.
So tell people again how they can reach the office and your website. You've got the greatest website with so much
Thank
great
you.
information on there.
Certainly go to the website, kbrlegal.com. There's lots of information on the website. We have articles, Rembaum's Association Roundup is there, Legal Morsels is there. We provide topical articles regularly. That's certainly available at no charge. It's even for non-clients, of course. But you can go to kbrlegal.com. There's a contact box on the opening page that you can fill out, and we'll get back to you very quickly. You can call 1-800-974-0680, and that will get you to any of our 4 offices. Or you can write to info@kbrlegal.com, and we will respond to you right away.
Your show is so easy to do. Thank everybody for all your questions. We really appreciate it. Robert will be back with us again next month, first Thursday of the month, 5 o'clock Eastern time here on W4CY Radio. Robert, have a wonderful Passover. We'll see you next month.
You. Happy springtime, everybody.
Thank you. That's attorney Robert K. Bender Rembaum. God, the show is so easy to do with all your questions you send in. We appreciate them. Hey, we'll see you again next week with more Ask the Experts.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.